Okay, moving on, case number 21, In Re JH. And I think both sides are endorsed in this case. Okay.
Hi.
Sir, please.
JH Pro Per. First and foremost, I want to give all honor and all glory and all praises to Yahweh. And I do so in the name of his only begotten son, Hamashiach Yahushua, who the world entity called Jesus Christ. Barakatha Yahweh, Barakatha Yahushua, Kwam Yasharala, in the book of Galatians, chapter 5, verse 10. Now, I have a lot written, but I want to just get to the hot facts because in my brief, I did a decent argument about subject matter jurisdiction, and the penalty rebutted stating, say, hey, his definition of subject matter jurisdiction is wrong, throw it out. And I was looking at their case law, Edens 2022, and Cross in his dissent, Justice Cross in his dissent, he stated there's a widespread and unfortunate practice among both state and federal courts of using the term jurisdiction imprecisely to refer both to the subject matter and to the personal jurisdiction of the court and to the court's general authority to take action. I was under the impression that, you know, personal jurisdiction is if you have like a traffic ticket, take it to the district court. If it's in this case, a petition for mental health, you take it to the probate court and subject matter. If the petition is defective, that is the crux of my argument. The petition is defective. It contains lies. Then the courts cannot move forward with it because it lacks subject matter jurisdiction. Now, if my argument of that definition is wrong, I'm not here to throw that case away. I'm not, because I got one more argument. I got two more arguments, but I got another thing that Justice Cross in his dissent, what he stated coincides with MCL. And he said, Supreme Court expressly held that the probate court lacked jurisdiction over the involuntary commitment of the respondent because the respondent had not been present at the commitment hearing, and the probate court had not been provided the statutory mandated facts showing that the respondent's presence would be unsafe or improper. Now that parallels MCL 330.1455. One in parentheses, it says the subject of a petition has the right to be present at all hearings. Just like Justice Cross said, at the commitment hearing, he was not there, so the probate court lacks subject matter jurisdiction. And then that MCL goes on to say, the court may exclude the subject from a hearing if the subject's behavior at the hearing makes it impossible to conduct the hearing. Now, and just like his dissent, he said at the end of it, showing that the respondent's presence would be unsafe and improper. So he paralleling MC law, saying if you violate this MC law, you lack subject matter jurisdiction. And one more part of this MCL, the court shall enter on the record its reasons for excluding the subject of a petition from the hearing. And that MCL says in the middle of it, the court had not been provided with statutory mandated facts showing the respondent presence would be unsafe and improper, meaning that the hearing dated Wednesday, February 15, 2023, I was not there to defend myself that, hey,
okay, that's the one where the judge enters the order to transport you for an examination,
yes,
right?
Yes, and I was not there to defend myself to say, because the petitioner, he selected 3C that has a competent clinical opinion clause to it. He never attached a competent clinical opinion. And then on the transport order, she said reasonable effort was made. But I got a question. Did you guys get the CD that I mailed you guys? And y'all heard it?
Yes.
So the day before the petition was filed, I told the petitioner, hey, I want to speak to a psychiatrist. And then on the day of the petition, he was just asking where I was at, that the police was looking for me. That's a district court, circuit court matter. I got Fifth Amendment rights to not self-incriminate. And then he selected 8 on page 2 of the petition saying non-compliant. Now I got another MCL to argue that. MCL 330.
Right. And just to make sure I understand what you're saying, the way that it works is, in order to have you brought in involuntarily for an examination, they have to show first that you are non-compliant, right?
Right. but they never
right,
proved that
right.
to Linda.
I understand. I thought you were talking about that. I just wanted to be sure.
They never proved it. Now about number 8 on the petition on page 2, he wrote non-compliant. Now, when preparing for this oral argument, I just recently figured this part out. MCL 330.14343 in parentheses. It says the petition shall be accompanied by the clinical certificate of a physician or licensed psychologist. Okay, that's not there. And then it goes on to say, unless after reasonable effort, the petitioner could not secure an examination. And he basically says that even though the petitioner is not telling the truth, if a clinical certificate does not accompany the petitioner says shall set forth the reasons. Now I'm looking at the word reasons. It's plural, not singular. He wrote a singular reason that goes against that law. Meaning that if somebody witnessed somebody doing something that raised an eyebrow, you say, look, I'm gonna send you to a mental hospital to get you checked out. The law states you gotta give them an extra chance to speak to a psychiatrist, physician, licensed psychologist more than once. Just like you get pulled over by police and police say, get out the car. Unless the police officer being racist, he gives the person more than one chance to get out the car. Every time I see this on social media all the time, meaning that the petitioner did not give me more than one opportunity to speak to a psychiatrist according to the petition he submitted to Linda Hallmark, Oakland County Probate Court, and that goes against that transgress MCL 330.14343. So anybody got questions?
No, I think I understand.
Okay, all praise to the Most High.
Okay,
All
thank
right.
you, sir.
Thank you.
Thank you very much, sir.
Good afternoon, Your Honors. Fozia Daher on behalf of Petitioner Appellee Mark L. Smith. I'm going to be very short today, and I'm going to defer to my brief on the legal arguments that we recited. I mentioned this in our brief also that Mr. Smith had very limited involvement in the probate court proceedings, and his interest was essentially represented through the Oakland County prosecutor. So I will defer to the probate court record as to any factual claims and can attempt to answer any questions the panel may have otherwise.
I just have one question. This hearing on February 15th that Judge Hallmark conducted, JH was not there, correct?
I don't have a clear answer to that, Your Honor.
That's okay. That's okay.
I don't want to say yes or no otherwise, just because.
Well, is your view that even if JH wasn't there, that didn't divest the court of the authority to issue essentially a pickup order for an examination?
Correct, that's my view, yeah.
No, I have no questions.
Nothing else.
Thank you.
Thank you.
Thank you. Sir, you get the last word.
The appellee stated that Smith involvement was limited. He's a guy who signed the petition. He the one who testified when I objected to his petition in front of Judge O'Brien, and he testified to the jury. So that involvement is more than just limited.
You did not attend a hearing on February 15th.
No.
Right? Your position is you never received notice.
I only found out that evening the police came to my home saying you going to common ground. And I complied.
I understand.
Any more questions?
No.
Excellent argument.
Thank you.
Thank
very
you
much.
both
so
of you.
much.
Thank you so much.
All praise to the Most High.
That case will be submitted. Thank you, everyone.